This is a paternity action filed in Greenwood County District Court by Brandon McCulloch back on or about November or December of 2024. Kind of trying to figure out why the emergency temporary order was signed on November 26, 24 in 24 DM 53, but the petition wasn't filed till 12/3 of 24. But be that as it may, that was around the time frame of this case being filed, with a notice of hearing for December 13th of 24, at which time Mr. McClendon appeared with his client, and we were advised that there was no service that was obtained. It was rescheduled and still no service obtained. An alias summons was issued and still no service has been obtained. And I don't know if I made an actual finding, but Mr. McClendon alluded to the fact that he believed Ms. Mock was avoiding service, that efforts had been made in Jackson County, Missouri, I believe, to serve her, but that she wasn't accepting service of this case. It all arose, though, out of a PFA that was filed in Greenwood County from an incident that happened in Lyon County, because Mr. McCulloch is a resident of Greenwood County. I believe he lives in Madison. But anyway, Judge Webster issued a temporary order of protection from abuse in Greenwood County District Court case in 2024 DM 52. Which is probably what prompted emergency ex parte order to be filed based on that action, but that action did not include the child initially. The child was referenced. The child was present during the incident in Lyon County during an exchange, but it does not look like Judge Webster included the child in that order. Subsequently, Ms. Mock filed her own paternity action in Jackson County, Missouri, after Greenwood County case was filed. And she did obtain service, and both parties had at least temporary representation. In that case, and I believe an order of stay was issued pending the motion to dismiss filed by Ms. Mock by and through her attorney, Mr. Miller. I guess not filed by her. She's still not accepted jurisdiction of this court, but filed through counsel. A motion to dismiss, it was stayed. I did confer with Judge Jessica Agnelli after we got a copy of her order where she continued a hearing and stayed the proceedings. And it's my understanding during our UCCJEA conference that her analysis anyway with regard to staying the proceeding is she believes under UCCJEA, the jurisdiction lies with the jurisdiction in which the action was first commenced. So she did not make a finding, unlike a petition or temporary order in a divorce case, that first served takes priority, but rather if jurisdiction could be had in either or both jurisdiction, that commencement is controlled. Now, you all can correct me if I'm wrong, but my take on this case, and I noted that in my order, my emergency protection order, which my view is that under a PFA, the court can always take temporary jurisdiction of children, but it's temporary, and should defer to any domestic filings involving custody unless there's direct abuse of the child that warrants a long-term PFA. But at any rate, my take when I noted their custody arrangement was that this is not a divorce case. There's no divorce on file. There was no custody case on file. This child was 8 years old. So these parties had been sharing this child. Dad was acknowledged as the father. He has the last name, and I believe he was on the birth certificate. So he's presumptively the father of this child. And although they hadn't been awarded joint custody by any court or shared custody or a parenting plan on file, that essentially they were engaging in the sharing of this child. Even when she moved to another state, they shared custody of this child. Maybe not shared custody in the custodial sense of a shared residential plan, but just shared custody of the child. So, I issued a temporary order and took jurisdiction of the case, but I anticipated service on Ms. Mock that was not effectuated for whatever reason. And so we're here on a motion to dismiss, and I believe a stay on the Jackson County case. But you all can correct me as we go through. That's just sort of my general summary of what I understand the current status of the case to be. And Mr. Miller, it's your motion to dismiss, so I'll let you proceed first.
Very good. Thank you, Your Honor. I know that there's been a flurry of filings this morning. Has the court had an opportunity to review those?
I think I reviewed at about 11:45 or something, the answer to the there was a response. There was an answer to the motion to dismiss. And then there was a response to petitioner's answer by you. But other than that, there are a couple of exhibits that have been sent here that I really have not looked at. And if you had any exhibits, Mr. Miller, I've not looked at those either.
Very good. Your Honor, if I might bring you to speed, at it looked like 11:03 this morning, opposing counsel filed a response to my response indicating that the Missouri case had been dismissed. I think that's probably an overstatement. I think that they also sent us a copy of the order staying the proceedings out of Missouri, and there is a case management conference set September the 2nd, 2025 at 9 a.m. So the Missouri case has not been dismissed. It stayed as was this case. Judge, if I might, as kind of a explanatory situation, I think you're pretty good on the facts to date. However, the filing by the petitioner in this case was based upon his claim that Kansas was the UCCJEA home state. And of course, this court is well aware that there has to be at least 6 consecutive months immediately before the commencement of the custody proceeding. And in this case, that is not what happened. Mr. McCullough did not disclose to the courts that the child had been living in the state of Missouri in his UCCJEA affidavit. Yet, as indicated in my response, in his answer, he had indicated that the mother lived in Missouri from May 18th of 23 to November 23rd of 2024. That would certainly indicate that the child lived in a different state within the 6 months immediately preceding the filing of the commencement of this matter. He also testified in a PFA case in Greenwood County that she's only been in Kansas City for about 1.5 years, Your Honor. So even under his sworn testimony.
Where, I don't have, we need to mark the petition or whatever document you're referring to, because I don't know for sure whether he was referencing that mom had been in Kansas City just that long, just the year, or if the child.
That is included in the transcript, Your Honor, and that's kind of the problem with doing this by Zoom when I have 6 or 7 witnesses and multiple documents. But the court could take judicial notice, and the real concern is the UCCJEA affidavit in this Greenwood County case that indicates that the minor child lived at, and then he references June 24 to current, and it says Eureka, Kansas. Doesn't say that was Myrisha, and then there's a Brandon McCullough indicating that he had lived there. But as far as where the child has lived, he does not indicate or disclose to the court that this child had been living in the state of Missouri immediately preceding the filing.
Okay, well, I will take judicial notice. I guess that will be, you want that to be respondents 1?
Yes.
I mean, A, I'm sorry, A.
A is fine, Your Honor.
Okay.
But
Yeah.
based upon that, Your Honor,
Well, that, but I don't have the transcript.
I know we just got it yesterday morning,
Okay.
and I wasn't sure how you wanted to do this. Like I said, I know during COVID we did a lot of Zoom evidentiary hearings, but since then I know most judges don't like that, especially when we've got a lot of documentation and number of witnesses to testify.
Well, I prefer in person, but I can't always expedite hearings in Greenwood County because of availability of courtroom and making sure it gets cleared with everybody. Also, I knew your client was from Kansas City and there might be witnesses from different locations. And I thought I was accommodating the parties. And I wanted to get this set, relatively quick, especially given the fact that your client is not receiving any visitation of the child. But I am happy to schedule this in person if you feel like your client would get the kind of, hearing that you want, and do that. I guess I was just trying to get something moving in this case.
I understand that,
So many issues.
it is a significant issue for my client. However, as indicated, this PFA that has been filed, the child is not listed as a protected party. And there's really no reason why the incidents were between the parents and not the child. So that's part of the motion to dismiss that I have filed herein. As far as the UCCJEA jurisdiction.
Right, that's a legal matter, and I do want to hear from you on that. But just keep in mind, for me, if a child witnesses domestic abuse between parents, that can be as damaging as abuse, smacking them or hitting them. But I don't think that the case law necessarily supports that for a 1-year protection order involving a child. I think that it really has to constitute physical harm to get a final order that involves the child with no contact at all by the other parent. So I just want you to know, just because it was between the parties, I do think it is important or a factor that the child was present. But go ahead.
All right, very well. Thank you, Your Honor. If you want to get to the legal analysis without having UCCJEA jurisdiction, or at least trying to get that without disclosing to the court that the child had been living in another state within the 6 months immediately preceding the filing of his petition, I think there's been kind of an overstep and maybe a misrepresentation. There was no need for an emergency jurisdiction in this case because the child was not one of the protected parties. If the court wants to hear testimony today, I can attempt to do it. I think it would probably be easier for the court to have the parties in person, though, as well as the witnesses and the exhibits. I would ask the court to consider lifting any no contact order and allowing my client to have parenting time in pending the actual in-person hearing for presentation of evidence.
How do I ensure, though, with either one of these parents and the measures that they've gone to and the controversial nature of these proceedings and their relationship, which is high conflict? How do I ensure that either one of them aren't going to run off with the child and not return jurisdiction to whatever court makes orders believing that it has proper jurisdiction until or unless appealed to a higher court?
Okay, Your Honor, my response to that would be the KSA 23-3203, that obviously withholding a child from another parent is a consideration of the court. I have also, as a practical matter, told my client that in the event that you were granted visitation and that you did not comply with court orders, that pretty much ends the argument. And I'm sure that the court would take compliance with the existing court orders into effect. I'm quite frankly a little stunned that with the misrepresentation of the court that he had UCCJEA jurisdiction without disclosing what the facts were, that there may be, as well as some of the wording in the pleadings, that there might be an overstep to try to gain an advantage.
Okay. How about this question? If you are asking for a dismissal based on law, UCCJEA, and the argument that this court does not have jurisdiction, not home state jurisdiction or even UCCJEA jurisdiction in this matter, then how do I have, she's not accepted jurisdiction of this court, how do I make orders for parenting time without having jurisdiction of her in this case?
I guess that's why you wear the robe, Your Honor. But if the court just wants to take the legal question, because if you don't have jurisdiction, then the matter should be dismissed. I think we've laid out in writing the answers to the legal inquiries. But as far as the parenting time, that's where most of the witnesses lie, as far as the validity of their presentation, because we do have an admission in the answer of where the child had, it's in the petitioner's own answer that the child had lived in Missouri. So he did not have 6 months of consecutive Kansas residency for the child before he filed this matter. But
what about his argument that the the majority of her life was spent in Eureka or Greenwood County, Kansas, and or Lyon County, but definitely in Kansas. And that even if she was there with mom, that it may or may not been intended for her to return. I mean, how do you look at residency when a child is born in a certain state, has significant ties and connections there? Dad's still here. He's never left. They're sharing custody, even though there's no court order. But she's going to see mom or staying with mom in Missouri.
Well, Your Honor, the answer to that is she wasn't just visiting mom. The fact is, and I think the statements that the petitioner has already stated is that the child moved with mom to Missouri and had been there for a year and a half. I believe the visitation was where the father was getting the child on the weekends. And so if you're looking at it from the time spent analysis, the child was living in Missouri with mom. So I think that with the most recent period of time, most time with the child being with mom in Missouri, that's where the more relevant witnesses and evidence is going to be, not what was going on a year and a half, 2 years ago at this point in time, but what had happened up to the date that this hearing had, when this incident occurred.
Judge, if I could say something real quick.
I was just getting ready to get to you. So, yes.
Judge, the respondent is contending that Missouri is the home state. I submitted as evidence today to the court for this hearing. There is an order from that Missouri court, and it says in it, quote, Missouri is not the home state of the child, and this court does not have statutory authority to enter initial child custody determination under the UCCJEA. So Missouri has already claimed they're not the home state. That leaves Kansas as the remaining court of jurisdiction.
Your Honor, the rest of that order staying proceedings says, though, however, pursuant to Missouri law, this court shall stay further action until the court in Kansas makes a determination on whether it will accept home state jurisdiction. In the event Kansas does not accept home state jurisdiction, this court will accept jurisdiction if otherwise appropriate to UCCJEA, and it set the matter for a case management conference in September.
And I would like to address the emergency temporary jurisdiction issue.
Okay. All right. Go ahead.
Judge, the respondent was arrested on the date in question. Once she's arrested, that child was abandoned by her, and the father had to step in and take custody. That is a grounds for that emergency jurisdiction. And as soon as that happens, this court has the jurisdiction of this case.
Your Honor, in response, I would suggest to the court that she was not permitted to have any contact with the petitioner in this case as a result of the PFA that he immediately filed. So she was not able to make contact with him to try to gain the child back. And in contacting Missouri Council, she was able to finally get the paternity matter on file.
Well, I am finding that this court had emergency temporary jurisdiction. The child was physically present in this state when this incident occurred. And if one parent becomes unavailable for whatever reason and lives in another state, whether it's a car accident or whatever, they get arrested or whatever the case may be, and the other parent needs a lawful court order or wants one of custody, I think that, I mean, mind you, there's substantial ties and connection to these communities and to the state, but setting that aside, I believe that there was emergency jurisdiction, but we are past that now. We're trying to make a determination about final jurisdiction or exclusive jurisdiction, what court has that? I think that they can move to dismiss our temporary jurisdiction because it's their belief that Missouri has proper jurisdiction and will exercise jurisdiction if this court dismisses its action. Or I think this court can find that it has controlling jurisdiction and that I think the other state will defer jurisdiction to this court based on the commencement of the proceeding in Greenwood County that predates the Jackson County, Missouri case. Let me look here. You know, part of the problem here these days I'm finding, and there's no real solution to it, is these laws were created during times where things were more traditional. And where folks were married, got divorced, moved to another state. People are much more mobile and they're acting without any court orders into teenage years of a child's life. And it's hard to determine what's actually been de facto and what, where the jurisdiction lies sometimes.
Your Honor, may I say something quickly?
Yes.
I think when you talk about commencement of an action, you don't just have the filing, but you also have service as the component of the commencement of an action. When you're looking at jurisdiction on statute of limitations and things like that, if you don't get service on them, your time can run. And I think that's the same analysis this court should make, is that although the filing occurred, they didn't get service on my client until well after he'd been served. In fact, looking at things, it appears that the summons was not issued until after he got served.
All right, well, hang on a minute.
Yep.
I didn't say that was my necessarily finding and interpretation. I said that it was my understanding that when the Jackson County Judge Agnelli, made her determination, she made it based on her belief that UCCJEA, when it talked about commencement, she believed that to be equivalent to filing an action. And his paternity action to seek custody orders was filed first. So, December, January, February.
Your Honor, if I might, the bulk of the testimony and evidence regarding the child's environment, observers, et cetera, would be in Missouri, not in Kansas.
So if no state qualifies as the home state, a state can exercise jurisdiction if the child and at least one parent have a significant connection to the state and substantial evidence about the child's care is available there. That applies here, but what constitutes a finding that there is essentially no home state? And that was my question to you. Can this court find, because there was no lawful custody order in existence, and these parties just had sort of an informal arrangement, and they each got parenting time, because I think before that year, she lived here, she lived there, she went to school here, then she went with mom, that they shared their arrangements with the child, that there really wasn't a permanent intended home state of the child. Can this, because if this court finds that there's no state qualifies as the home state per se, that Kansas has jurisdiction because dad has remained here. And this is where the child was born and has substantial ties and connections. Even your client has substantial ties and connections to Greenwood County. And what I'm reading here, that I have to look at UCCJEA every time and try to retrace and reestablish the connections there. But it clearly says in situations where a child is at risk, the court can exercise temporary jurisdiction to protect the child, even if it's not the home state or a significant connection state. I think this was a significant connection state, but either way, temporary jurisdiction was appropriate.
Can I add something?
Yeah, just a minute.
Okay.
All right. Yes, response.
Judge, I think under 204B, that temporary emergency jurisdiction can become the final determination, and it can become the home state of the child if no other state has any prior child custody determinations. And so I think, or proceedings. So I think that's what we have in this case. So that emergency jurisdiction can turn into the home state.
Okay, give me that site again that you're relying on.
It's 204B, and then the Kansas one is 23-37-204B.
Give me just a minute. That would kind of make sense to me in situations where parents just engage in parenting and custody back and forth with no real orders, no real child support, nothing. It's just very loose and very informal, no matter where it's occurring at. That would make sense to me, but I don't know that that is. I don't know that's how it reads. Just because I think something makes sense to me doesn't mean that's legally correct.
My concern, Your Honor, is that there was not 6 months underneath the belt before he filed, even though there might have been emergency, that not automatically extend and give him the right to use the emergency orders. Since he precluded my client from having contact with the child and returning the child to the state of Missouri. I think that's a factor that court should take into consideration, that the relevant evidence prior to the event would be in the state of Missouri, not in the state of Kansas.
Was she enrolled in school in Missouri? Did she attend?
Your Honor, she was homeschooled in co-ops, and there is documentation of the same. One of the witnesses that we have, well, several of the witnesses would be able to talk about that. We've got Any Schoolers Casey General Group, which was 3 to 5 opportunities weekly. Any Schoolers Casey Cooking Group, Any Schoolers Casey STEM Group, Johnson County Homeschool Get Together Group, Casey Clay Guild, Foundry Homeschool Fridays, Casey Homeschool Art Collective, and Hike with the Naturalist Group. That's just the schooling. She was involved with the Raytown soccer team, Johnson County Homeschool Get Together Soccer Play Group, Her doctors were in Kansas City. She attended church in Raytown, Missouri. And so I'm suggesting to the court that the relevant evidence of what was going on immediately prior to this event would show that her primary exposure would have been to the state of Missouri for the relevant evidences of the home state.
Well, we need to look at AW, which is a 2021 case, because what this says, and I believe that that's what's occurred here, emergency jurisdiction under the UCCJEA indicates that any temporary emergency orders issued become final in the absence of any orders from a home state court, suggesting that temporary emergency jurisdiction can ripen into home state jurisdiction once the home state declines jurisdiction. Missouri's declined jurisdiction based on its order. So whether you like the way it was worded or not, they've stayed the proceedings because nobody wants to risk the fact that this child just falls into a crack. But I believe the nature of the order, and based on my conference with that judge, is that she's deferring jurisdiction to Kansas. So we need to look at AW. So we're going to be in recess for 10 minutes. I know you have witnesses, but if we have to get to the technical facts of the UCCJEA and its application and be in agreement, or at least me have my perspective. Otherwise, we don't need a lot of this other evidence. So we're going to be in recess for 10 minutes to look at that case. Thank you. All right, counsel, I think that JBB versus JLB. Oh, that's not the one that it was. That was In Re AW. In Re AW. 29, volume 60. 60 Can-App, second 296. 493 P3D 298 starts to give us direction, I guess, as to the rules of UCCJEA, but it certainly is not a case on point because the father was deceased and it was not litigation between two parents. It involved DCF, social workers, government agencies, and child in need of care proceedings, potentially. So I don't, it doesn't unilaterally answer all of my questions. I think what we need to do is I need to have each one of you present any testimony that you think's significant for you to make findings of fact and conclusions of law to submit to the court. And I'm going to have to issue a written opinion on the jurisdictional issue. We really don't get to parenting issues or further custodial issues until there's a final determination that can be appealable by one party or the other as to UCCJEA jurisdiction. You know, if you look at it from a perspective of the UCCJEA really was intended to have uniform rules and also to avoid disputes between states. I mean, clearly, the judge in Missouri has deferred jurisdiction if this court accepts jurisdiction to us. But I'm still seeing in here that for an initial order to be made, it has to be home state. And I'm not 100% convinced that this emergency order ripens in to jurisdiction because the child was not intentionally abandoned, nor was there a threat of harm to the child or abuse by mom at that moment. So I'm not sure that we've got the application of these things. And I cannot make a determination or necessarily assert anything to Judge Agnelli because I hadn't heard any evidence other than the filings, you know, in the court file. So let's get some evidence laid out that you need to do your proposed findings of fact and conclusions of law. And I'm going to have to make a written ruling from that. And I hope to do that within 14 days. Okay. All right. I'll go ahead and start with you, Mr. Miller. What I definitely think each party needs to testify as to how much they had the child, etc. And let me say this. I did note by reading that case that case stated that we don't look at the child's residence like we do a legal resident in terms of their intention to return. Their subjective intent is not what they mean by residence for purposes of home state. So where I made that comment, you know, previously, do we look at that? You know, what was the real intentions here? I don't think I can, that I would apply that rule that it's not where the child's physically present at, but where the child may be intended to return. I don't think I can do that same kind of analysis. So I just want to let you know that I have corrected my thoughts in that regard based on looking at that case. All right, Mr. Miller. We've got an hour here, so each of you gets 30 minutes and make the best use of it you can.
You're muted, Mr. Miller.
All right, Your Honor. Thank you. One point I would like to make before I start the testimony is that AW case does specifically provide that if there were temporary orders, that it has to state how long those temporary orders were to be in effect to give everybody notice. I don't think that happened, but I'll let the court take a look at the orders themselves to do that. I would call Ariana Mott.
But they both filed paternity. I mean, this isn't a case like that where nobody bothered to file anything anywhere, even though there was an existing temporary order. So I'm not sure that that's significant, but again, you can make all the arguments you want to when you submit your findings. But both of these parties took action at different times.
All right.
So, all right.
Thank you, Your Honor. Call Ariana Mott to the stand.
All right. Ma'am, if you would raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Thank you. You may proceed, Mr. Miller.
Please state your name for the record.
Ariana Moore.
And are you the mother of the child in question?
Yes.
And when did you and the child move to the state of Missouri from the state of Kansas?
In May, after she finished school, May of 2023.
All right. And was that with the father's permission?
It was, yes.
And did the two of you have arranged a parenting time schedule with the child?
Yes, even prior to our move, Maya was with me every Tuesday through Saturday. She spent that time with me because her father worked Wednesday through Saturday. So I kept her from the Tuesday evening through Saturday evening every week. Most of the time, there were several weeks that we kept her even longer than that. During that year and a half prior to the incident that happened of us living in Kansas City, I documented the days out with the text messages to exchange to back those up. During that year and a half, Maya spent approximately 379 days with me and 150 days with her dad in Eureka. But the 379 days were with me in Raytown, Missouri.
Okay. As far as the connections with the child in the state of Missouri, can you give the court a list of contacts that she would have with the state of Missouri?
Yeah, she's got several friends in our neighborhood. We've got neighbors that are there. She's also participating in several homeschool groups, several co-ops. She participates in Any Schoolers, which is a general school group. She also participates in Any Schoolers KC, which is a cooking class. And then she also participates in Any Schoolers KC STEM class in Kansas City. She's also a member of the Johnson County Homeschool Get Together group. They get together 3 to 5 times a month and do various homeschooling opportunities and events. She also participates in a homeschooling class at the Casey Clay Guild. And she also participates in Foundry Fridays, which is just a playful Friday day for the kids to get together that are homeschooled. She's also a member of the Casey Homeschool Art Collective. And she also participates in Hike with the Naturals group, where they just go and learn about nature and we take hikes with the other homeschool children. She's also on the team for Raytown Soccer, and she participates in that. And then
let me ask you a question. Do you know if she participates in any activities in Kansas during that year and a half when you were living in Missouri with her?
No, she was not participating in any activities during that time in Kansas.
Okay, keep going, please.
She also has doctors. Her primary care doctor was Mark Basham. He was aware that she was living in Kansas City. He would call in prescriptions for her if we needed to the Raytown pharmacy there where we live. And she also seen a Dr. Frey, which was her chiropractor right there in Raytown, Missouri. She also seen multiple physicians at the Kansas City Adele Children's Hospital campus for spine issues that she had going on. And she was even treated in the emergency room there just before this incident occurred in November 2nd of 2024. We also are members of a church in Raytown. We've been members of that church for approximately a year at the time of this incident occurring. She went to children's church with us when she stayed over Saturdays on multiple Sundays with us, and she attended church events and youth group on Sundays.
Okay.
Okay, and you stated Dr. Basham was still listed as her primary physician in Eureka, correct?
Yes, we would just drive her back to go to the doctor if she needed to go there, just because it was hard to get her established with the new PCP in Kansas.
Okay,
Familiar with him.
okay.
Are there medical personnel in your family?
Yes, my fiance is actually a physician himself.
And was there a discussion with Dr. Basham and your fiance about the propriety and what would be best for your daughter if the primary care remained here in Kansas?
Yes, it was just, they would confer with each other if need be, since he lives with us in the residence, and they communicated with each other about things that were going on with Maya.
Okay. Were there communications with the child's father regarding allowing the child to be in Missouri that would suggest that he objected to her being there?
No, none at all.
And what was your understanding of where the child's residence, the primary residence was?
With me, she was with me a majority of her time.
Okay. Did you procure a transcript of the testimony from the PFA arising from the incident on in November of 2024?
Yes, I did.
And was there discussion about where the child lived during that?
Yes, there was.
I'm going to direct you to, I guess it would be the very bottom of page 17 and the top of page 18 regarding that series of questions.
Okay.
Who was testifying at that time?
Myself and Brandon McCullough.
Okay. And so was there a discussion about how long your child had been in the Kansas City area?
Yes, we were discussing, at that point, Marion Shirley was representing me. She had misspoke and stated that Maya had lived there for approximately 2 years, and to which Brandon responded, stating that she had only lived in Missouri for about 1.5 years, Your Honor.
Did you believe that to be an admission that the father believed the child to be a resident of the state of Missouri during that time?
Yes,
Do you believe that the bulk of the evidence regarding the child's development at this point in time would be in Missouri, where she had spent the bulk of the last year and that, well, it'd be about 2 years now.
in Missouri?
Yes.
Yes, I do, because she developed into many groups and activities and friends that we've created a school environment and a home environment there with lots of people surrounding her life.
Okay. Have you attempted to gain any parenting time with your child since you were served with these protective orders?
No, out of fear that it would cause further issues with the court.
Okay. And that being said, you did file particular pleadings within the state of Missouri, is that correct?
I did, yes.
With the timeframes involved, what was the reason for the delay from November to when you did file?
Because I was aware, I was told under rumor that Brandon had filed something, but I had never been served with anything. And so waiting to see my child, I really needed to get something going so that I could see her. And so I was waiting for him to get that served to me so I could object to the Kansas filing, which that didn't happen. So my Missouri lawyer suggested we go ahead and file since I had not been served.
Okay. And do you know if the Missouri process was served on the child's father before his Kansas service was obtained upon you?
Yes, I believe it was. He was served on May 1st, and I believe I was served approximately 2 weeks later.
Okay. How many witnesses do you think there are that would be relevant for the court's consideration of your child's presence in the state of Missouri during that basically 18 months time period before this incident?
Actively today, I have at least 5 people willing to testify over Zoom. There's multiple others. I would say probably 10 to 15 in total I could gather, but actively today, there'd be 5 willing to come forward right now.
Okay. The series of events that occurred on that November date in 2024, what was the purpose of the meeting between you and the petitioner?
As regular, Brandon gets off work that Saturday at 6 p.m. And just like every other weekend, other than the time she stayed to go to church on Sunday, I would meet him. Since I lived in Raytown with Maya, I would drive down to his employer at Simmons Pet Food to exchange custody of Maya so that he may have her from Saturday until Tuesday when we exchanged custody again.
Okay. And you were not convicted of any of the offenses alleged in the incident of November 2024, were you?
No, I was not.
Based upon the activity documentation that you have, do you believe that the substantial portion of the evidence relevant to home state is going to be in the state of Missouri?
I do, yes.
His action was filed apparently on, give me just a moment here, Your Honor. His action was filed on November 25th of 2024, is that correct?
Yes, it is.
And had the child lived in the state of Kansas for UCCJEA jurisdiction to attach?
No, she was exchanged to her father that previous Saturday, and prior to that, she had spent a majority of her time with me in Raytown.
Are his allegations that the child lived in Eureka, Kansas only a correct representation of the facts?
No, they're not.
Are you asking this court to dismiss this case based upon the fact that Kansas is not the home state and what was provided to the court was an inaccurate statement of facts?
Yes, I am.
You understand what your obligations as far as a parent would be to allow ongoing parenting time with him in the event that the court retained jurisdiction for allowing him to see the child?
Yeah, I understand that it's very important for my daughter to have both her parents in her life. I've always enforced that issue, and that's why we've never gone to court prior to that, because I didn't need someone to tell me that. So I've always made sure that he's been a part of her life. And I plan to continue to do that.
Now, just so we're clear, your agreements were never reduced to writing or filed with any court before or even after you moved to Missouri, correct?
That is correct, Your Honor. They were just verbal agreements between the two of us.
Okay. And counsel, can you make the transcript plaintiffs 2, and I will take judicial notice of it and make sure that Mr. McCulloch's counsel gets a copy of it?
What do you want to mark, Your Honor?
I think it would be respondents 2, or respondents B, I'm sorry.
Okay, that's what I wanted to make sure.
Yeah,
Um,
and that would be the PFA transcript with Judge Webster.
that is,
You refer to as statements made about
all right.
custodial or residency implications.
Would it be a benefit for the court to have the color-coded schedule of the dates that the child was with my client and the dates that the child was with the petitioner?
Well, I mean, you have to offer that as an exhibit. if you want
That's
to
what I'm doing at this point in time. I'm making that offer based upon the testimony of my client.
As C,
Yes, Your Honor.
any objection, not necessarily, well, to the admissibility, but it's just the whatever weight. It's just her testimony at this point.
No, Your Honor.
All right, C will be admitted.
And I think we've already presented to the court in the various attachments with our original objection, a series of Missouri pleadings. We're asking the court to take judicial notice of those as well.
I don't know if I can take judicial notice of Jackson County, Missouri pleadings or not.
How about if I offer them? I don't know if the court wants me to get blue back versions or not, but
Yeah, they might need to be authenticated. And I would just do the whole file if I were you.
yes.
Okay,
I would offer that, Your Honor, as a respondent's exhibit D.
yes. Okay, I'm going to conditionally admit D if they provide authenticated copies. Mr. Stewart,
No objection, Your Honor.
okay, thank you. Anything else?
Your Honor, in the interest of time, and I do need to let the court know, I am also scheduled at 3 in front of Chief Judge Wine in a Coffee County contested matter. I apologize that I did not know that these were going to get shoved back to back, and that one has become extremely complicated.
Okay, is that a Zoom?
Yes, it is.
Okay. All right, cross-examination of this witness, Mr. Stewart.
Yes, Your Honor, thank you. Let's go back to the November 24 date. You were arrested for domestic battery charge, is that correct?
That is correct.
How long were you imprisoned initially on that case?
I believe it was 3 days total.
3 days. Was there anyone besides the petitioner available to help the daughter from your side of the family?
Again, she was dropped off to her dad. That was what the exchange was for. It was his normal visiting time with her. So there was nobody else needed.
Okay. Then also on that case, was there ever a no contact order between you and the daughter issued by Lyons County?
For Brandon and I believe there was.
So during that whole case, they never issued one against the daughter and you?
I don't recall, I'm not sure.
I know this, to me, this is formal, but it's informal. So if you, I want to make this happen. So if you want to ask that the court admit, it would be petitioners exhibit 3, which would be any bond orders or bond conditions and or any journal entries from Lyon County, I would admit and take judicial notice of those documents as well.
Yes, Your Honor, I'd like to do that.
Just don't rely on anything that Mr. Miller doesn't have and vice versa, available or provided.
Okay.
So does anybody, so I don't know the answer to that question. She says she's not sure. I don't know if you have any evidence, but if that's a point you want to make, you certainly can produce either a judge's order from an appearance or a bond ordering condition or a journal entry.
I'm not going to produce anything, Your Honor. I will reserve that for my client's testimony.
Okay. Go ahead.
How many exchanges would you say you did during that year when you lived in Missouri?
We exchanged approximately twice a week, every Wednesday or every Tuesday and Saturday.
Can you give me a total number for that?
I'd have to count. I've got about 65 pages of documents to show our exchanges. So if you'll give me a second, I'll gladly do that.
It would really help me if we focused on from May 1st or whatever, the 6 months prior to the emergency order or the filing of the paternity action here. What their schedule was, what the exchange was, how many days. I'm just still not convinced, Mr. Miller, that it's day for day kind of thing if they were essentially physically sharing the child.
Well, Your Honor, I don't know how you're defining shared. Way I see it is if she has the child 5 days and he has the child 2 days, that's not a shared custody situation. She was making sure that he got to see the child on his days off.
I mean, what I'm looking at for shared is she just testified that she drove to Kansas and dropped her daughter off to the father. That's shared.
No.
Right. Let's keep, I am really trying to make a record here. I trust both of you for appellate purposes.
Right.
So let's keep going to hear what her testimony is going to be about the sort of de facto, if you will, situation with these parties prior to her arrest in November. And certainly the 6 months prior.
Okay, well, I can start in October. There were 5 exchanges. And out of the October month, Maya spent 23 days with me and 8 days with her father. In September, she spent 21 days with me and 9 days with her father. And there were, sorry, I correct myself on the last, there wasn't 5 exchanges because there's twice a week, so 10 exchanges during that month. And then September, there were also 10 exchanges. And as I stated, 21 days with me, 9 days with her father. In August, there were 18 days spent with me and 13 days spent with her father and 10 exchanges there as well. In July, there were 19 days spent with me and 12 days spent with her father. and there were 10 exchanges there. In June, that was a little bit different month. During the week of June 9th through the 15th, Maya actually did not spend any time with either one of us. She was out of state with her grandmother and her aunt in Arkansas, which she was actually abandoned there by her aunt, who took off with the vehicle and left them and my daughter to get back on their own. Brandon's now girlfriend had to drive down there and pick them
I think we're kind of veering off.
out of that.
I don't think I asked anything about Arkansas.
Okay, sustained. Go ahead and stick with, you're doing a great job. Just stick with those months in your calculations.
Okay, yes, I apologize. So she, like I said, that week she wasn't with either of us. There was no exchanges that first week. So the month of June, she spent 21 days with me and 4 days with her father. And then the rest of that time she was spent with her grandmother and aunt. So there were 7 exchanges that month.
Okay.
Where did the grandmother and aunt live?
In Climax.
Oh, okay. They went to Arkansas. Okay, my apologies.
Correct, yes.
And how long were they in Arkansas?
As I stated, let me look again. From Sunday, June 9th to Saturday, June 15th.
Okay.
In May, Maya had spent 24 days with me and 7 days with her father. And there were, it looks like 7 exchanges for that. She spent a majority of that month with me going on vacation to Louisiana.
Okay. So I guess tell me more about your guys' verbal arrangement. Because it sounds to me like that was shared custody, but what was your take on it?
Ever since Brandon started his job at Simmons Pet Food, I don't know exactly when that was. I want to say it was about 4 to 5 years ago. We've had the same custody arrangement since then because he worked during that time Wednesday through Saturday. And so I always had Maya on those days because he had to get up and leave for work at 4 o'clock in the morning and didn't return home until 7:30 p.m. So Maya stayed with me during those times. When I moved up to Kansas City, because of the way his work schedule lines out half days on Wednesdays, we would exchange Maya on Tuesdays quite often, as well as Wednesday during midday. I would pick her up at 11 a.m. before he started his shift at Simmons.
And did you have any type of work schedule during this time frame?
Prior to this event, I was not working. I haven't been working since January 1st of 2024.
I guess prior to the move to Missouri, you were living in Kansas, correct?
Correct.
How long did you live in Kansas?
I grew up in Kansas.
Okay. So how long have you lived in Kansas?
I'm about to be 30 years old, so I would say 26 years or 27 years.
You've lived in Kansas for 27 years, is that what you said?
Correct.
What prompted the move?
I have been with my fiance now for going on 4 years. We were together at a little over 1.5 years at the time of my move and consent from Brandon. So we decided to let Maya finish the school year out there. She was being severely bullied in school. And so we both made the decision that even prior to deciding to move to Kansas City, we were going to homeschool her. And then since we decided to homeschool her, that made the move up there easier to work between her getting to see her dad and spending time with me as well. So we went ahead and moved up there after she finished school in May.
Tell me a little bit about this homeschooling. What kind of curriculum or schedule were you following on that?
Maya participated in 2 different accredited programs. She participated in MIA Academy and Splash Learn. And those were done just intermittently to supplement the paperwork that she was doing at home with a schedule that we created. I also have documents and stuff to back that up if I need to provide it.
Mm-hmm. Do you have any knowledge of her being held back in school?
I do, I'm aware. I called the school. She was already behind before she left public school. They were gonna have her in summer school. I have statements from the school on that as well. During her first grade year, she was going to be required to go to summer school prior to our move. And that was also a driving factor in why we started to homeschool her, because Maya was being held in special classes and needed more one-on-one time. So I'm aware she's been held behind, as she's still behind with school. She struggles to learn.
And so you're testifying that she was never enrolled in a Missouri school, is that correct?
She was homeschooled.
Yeah. How long was she enrolled in a Kansas school?
For a year and a half before, or I guess 2 years. She went to kindergarten and first grade.
You said 2 years?
Kindergarten and first grade, yes.
And then how long did you live in Missouri again?
A year and a half.
Okay.
I mean, I've lived for longer, obviously, but prior to this incident, a year and a half.
Okay. Tell me, what kind of health insurance your daughter has?
As far as I'm aware, she currently has her father's insurance. He's been telling me for 3 years that he was gonna get her on his work insurance, and I believe finally did as of January.
Has she ever had health insurance in Missouri?
No, she has not had health insurance in Missouri.
Is there any reason why?
Because again, her father continuously told me he was going to add her to his work insurance. And so I was waiting for that to happen.
So it sounds like right now she has Kansas and health insurance, is that correct?
Correct.
Has she had that most of her life, to your knowledge?
Prior to that, and prior to COVID, I believe in 2020, prior to our move, 2022 was the last year that we had applied for Medicaid. She was on Medicaid under me because she primarily lived with me. And I didn't make very much money, so she was on the Medicaid in Kansas for, honestly, probably almost since she was born, I believe.
So can you just summarize how many years you think that was?
(2016 to 2021) or 2022, I apologize, so 5 years, 6 years.
Okay. You said prior to you leaving for Missouri, you just said that you had the primary residential custody of the child, is that correct?
That is correct. She spent a majority of her time with me, and she continued to do so after I moved to Missouri.
Now, again, was that because of the father's work schedule?
Correct.
So he wasn't seeing her because he was at work? Is that what?
Because he was choosing not to have her in the evenings after work because that was more convenient for his work schedule.
Did he ever have her in the evenings?
No.
Throughout her whole life, he's never had her during the weeknights?
Anytime she was supposed to be with me, she was with me, unless Brandon had a special family event going on. He rarely asked to take her with him outside of those events.
But you said he still, so tell me again what days he did have the child.
During the evening,
No, what days did he normally have the child?
from you typically before we moved, it was usually Saturday. He would get her back Saturday night after work. We would drop her off there at his ending of his schedule at 6 p.m. And then she would return to me either Tuesday night or Wednesday at 11:30 a.m., which I would pick her up before he started his shift on Wednesday.
And who was we? You just said we would drop her off.
Several times my fiance had come with us.
So he would travel all the way to Kansas to be with you guys?
Yes.
Now, I'm sorry, you said just Saturday was the only day?
No, Saturday through Wednesday or Tuesday, depending on what Brandon worked. A lot of times he wanted to drop her off to me in Beto Junction on Tuesday. But if not, we would pick her up on Wednesday at 11:30 prior to his work shift.
Okay, so Saturday through Wednesday were Brandon's days. Is that correct?
Saturday night through Wednesday, yes. He didn't get her until 6 p.m. on Saturday.
Okay. I mean, that still sounds like half the time to me.
I have text messages to back up the exchanges. That'll be shared in the documents, I'm sure. Brandon and I have communicated about the exchanges on a regular basis through text. I would say there's at least 60% of these exchanges will be backed up by text proof, showing exactly how much time she spent with me. And as I said, I went through the dates. She spent a majority of her time with me because of the way his schedule lined out. And she spent several Sundays. She stayed longer to go to church with us as well. Those are also all documented in this document.
But I guess just what we're talking about right now is all the time prior to the Missouri move.
Mm-hmm.
And Saturday to Wednesday, that sounds like half of the time to me.
That would be the typical schedule outside of her staying later for church or Brandon dropping her off early on Tuesday, correct? But the way that the exchanges actually took place, that was our agreed upon schedule, was Wednesday through Saturday, because that was his work schedule. But that fluctuated often due to Maya staying for church and Brandon wanting to drop her off early instead of coming to meet me on Wednesday morning.
Does that sound like half of the week to you?
No. I genuinely had
Why
her
not?
Tuesday, Thursday, Friday, Saturday. I had her 4 days a week and my time was more than his. And the time she stayed over, I had her more than he did. Like I said, in just October, the month prior to this incident happening, I had her 23 days total. That's nights spent here with me, and he had her 8.
We switch gears here. Tell us the outcome of that domestic battery case.
What outcome?
What was the final outcome in that case?
I was offered a diversion.
Did you accept that diversion?
I did.
What were the terms of the diversion?
A monthly report by paper that I send to my diversion officer. And I do that for 1 year and then the charges are dropped.
Did you have to take a batterer's intervention program?
No,
Did they say why that wasn't required?
no.
So have you currently completed that diversion?
I'm actively on diversion right now.
What's your pending completion date?
March of this coming year.
March 26th?
Correct.
Are there any terms in that diversion that say that you can't have contact with your daughter?
There are not.
No further questions, Your Honor.
Any redirect?
Just quickly, as far as the 6 months time frame immediately prior to the incident, was there equal parenting time?
No.
And why is it that you did not contact the petitioner to arrange parenting time after the PFA orders were entered?
Because again, I was scared to cause retaliation from the court and further, I guess, complicate the situation of me being able to see my daughter.
Is that why you used legal counsel to take this course of action?
Absolutely, it is. Yes.
Are you asking to regain the principal place of residence to go back to the parenting time schedule that was in place immediately, the 6 months immediately prior to the incident?
To go back into place.
Yes.
I mean, I believe that would be best, but if he's saying that Maya needs to be in public school, then I think she needs to primarily reside with me so that she can go to public school.
I have nothing further for the purposes of the limited arguments today, Your Honor.
Well, I'm trying to understand. And make sense of, I do have a copy of the complaint. Lyon County 2024 CR 429 and the affidavit, which is just a report by him of the times that you threatened him and et cetera, et cetera. But basically you two are doing, without court orders, a pretty good job of spending time with your daughter and co-parenting her. I'm trying to figure out how this all erupted into what it's turned into when you guys were all in all doing a pretty good job without any court intervention and sharing time and custody of her. Were you mad? I mean, it's noted in here that you were angry. You guys were fighting about the fact that you had to do all the driving.
That is correct. I wasn't angry. I had approached him when I had got there for the exchange with a document that I had typed out of the mileage that I had driven, because I had simply asked him prior to meeting if there was any way he could meet me a little closer this time, because we were actually coming from St. Louis at the time. And he to which said no. And I said, okay, that's whatever. I don't know why you can't help a little bit more. I don't ask you for child support. I don't ask you for anything. He's came to Kansas City to pick up Maya 3 times in the year that we lived there, and that's it. Other than that, I drove Maya to him to convenience him picking her up. And at the time of that exchange, when I asked him about that, he began saying all kinds of things to me about how you just want money from me, just showing out for his brother or stepbrother, or sorry, his sister's husband at the time.
Okay.
And so that just erupted from there after he shoved me.
Sometimes though, when people want to move and the other side agrees and isn't going to file something, somebody will say, I'll bring her to you, or I'll make sure that you know, did you have some kind of arrangement about transportation that kind of helped ease his consenting to her moving or not?
No, he agreed to us moving prior to that. I was in communication with him. Like I said, I've been in a relationship with my fiance for 4 years now. And he was well aware of the relationship that we had. Brandon actually met my fiance prior to Maya meeting him. And we were very well co-parenting through that situation and communication. He was very happy for me and fully consented for Maya to make that move. The only reason I had offered, just out of the kindness, because I wasn't working for a while and it was easier with my schedule to exchange her to him. And I also had family here that I would occasionally visit when I came down. So
Okay.
It was just a courtesy.
Okay. Okay. If a court, any court, ordered joint and a semi-shared schedule, something similar to what you were doing, do you know any reason why it couldn't be executed?
No, Your Honor, as long as I could homeschool Maya still, that schedule would be perfectly acceptable to me. That gives Maya time with her dad. And
Are you willing to have her evaluated again? If a judge anywhere would order her to be evaluated academically to ensure that her homeschooling was sufficient, would you be willing for her to be tested?
yes, Your Honor. Like I said, I haven't worked since January of last year, and the reason for that is because Maya was behind. So I actually quit my job in order to focus more on her homeschooling prior to this happening, because Brandon wasn't really helping with her homeschool. So I would be willing to do that as long as there is some accountability for him to also help with her school while she's there to do some studying.
Okay, but clearly you're a better I could never homeschool my kids. So, but you two made an agreement. I mean, this wasn't something you just went off and did and didn't enroll her in school. You both understood that with this move, she'd be homeschooled, and then you could easily transfer her back and forth to one another if she wasn't in a public school and could be homeschooled.
Yes, Your Honor.
Okay, fair enough. Anything further, counsel?
No, Your Honor.
All right. Would you, Mr. Seward, like to call your client?
Yes, Your Honor. I'd like to call Brandon McCullough to testify.
Okay, sir, if you raise your right hand.
Your Honor, may I take a break to send notice to Chief Judge Wine that I'm running behind?
Do you think he would give you 10 minutes extra or not?
This is a very contentious case, much more so than this one.
How long is it gonna take till 5?
It's set until 5.
Okay. Well, let's get, yeah, go ahead and let him know. I'm not gonna let him go past 10 or 15 minutes, but I want to hear a little bit from him. And then what we're gonna do in fairness to complete the hearing.
Staff is notifying. Thank you, Your Honor.
And I apologize, I've been asking questions that have slowed things down.
Did we already swear Brandon in?
Raise your right hand. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Is there any way to shed a little bit more light on your face so I can?
I can open a curtain.
Yeah, do that, please.
It might
That
make a glare.
didn't do much.
Made
Okay,
it worse.
close it. Yeah, forget it. Go ahead. Go ahead. Mr. Seward, go ahead.
Brandon, tell us a little bit about your understanding of this prior custody arrangement.
I mean, more often than not, I had her, as she said, Saturday after work to most of the time I had her Wednesday at 11. And I have people that can testify to that, the people that ride with me to work.
How many people did you have available to testify?
I have 2 that ride with me to work every day.
Yeah. So they have a lot of personal knowledge of everything.
Yes.
So
There
you
was
kinda
exceptions where, do what?
Go ahead.
There was exceptions where she asked to keep her for church and I agreed to it, or she would make vacation plans. And I mean, I couldn't really tell her no to that kind of stuff. So she was going to do it regardless.
Just kind of tell the court what, prior to that arrangement, you guys all lived together, correct? At the very start of
No,
this.
we lived together for a few years, but she has a house on the south side of Eureka at 318 South School, which she currently still owns.
Okay. How long did she live at that house with? And you guys had a back and forth custody agreement?
I want to say, I don't quote me on it because I don't know the exact dates, but I want to say 5 or 6 years.
Okay. How long in total do you think she lived in Kansas?
Over 20 plus years. Or are you talking about Maya?
The respondent first and then Maya.
Maya lived here until she was 6, a little over 6.
Maya lived in Kansas for 6 years.
Yes.
And then
And occasionally after when I got off work, I would go see her. But when she lived here. But when she moved up there, it wasn't an option. I can't drive 4 hours to spend a couple hours with her.
yeah. I guess what was your understanding of the informal custody arrangement after Maya?
I would have her for no.
There might be a little bit of a time delay here, Brandon, but did you think either one of you had primary custody? Or did you think it was joint?
No, I did not. I thought we shared it.
I think you cut out there a little bit. Can you repeat that answer?
No, I did not. I was under the standing that we shared custody.
Were there any other, caveats to this arrangement?
Not a lot of. I mean, we pretty well stuck with our scheduled days, unless she had a vacation or I had a vacation. I did take Maya with me a couple years ago to spend a week and a half with my father in Minnesota.
Judge, were you able to hear all that, or was he cutting out for you?
No, I heard him.
Okay, you're just cutting out on my end. Brandon, tell us a little bit about the domestic battery incident last November. Tell us kind of what happened.
She showed up, and as she stated, she had to drive from St. Louis, which I had no control of where her fiance decided to try to work. My truck needed repairs, and I could not make her in-law. And she was agitated about it. And she, after arguing and me trying to get loaded up, she stepped in the door, and then we argued some more, and she struck me in the right side of my face and then struck me in the left side of my face when I got out of the truck, which there's a video for all of that.
And then do you know who called the cops that day?
She yelled at her fiance, EL, to call the cops.
They called the cops after attacking you.
Yes. Yes.
And then tell us what happened next. She was arrested?
Well, an hour and a half later, they arrested her after watching the video, yes.
Okay.
I had lacerations to my right ear, my nose.
Tell us a little bit about that criminal case. You said it was in Lyons County, is that correct?
Yes.
Tell us about some of the proceedings in that case that you went to.
I wasn't part of the proceedings. The DA just called me and let me know what was going on.
Okay. Did the DA tell you that there was ever a
But
no
the DA did
contact?
inform me that she was to have no contact with Maya because she was a witness. And it's to my understanding, she knew that because she asked the DA, or her lawyer asked the DA to grant visitation.
Judge, I'm having trouble hearing the answers and they're very lagged and delayed. And so I'm not getting a full response on my end. I don't know if it's my computer or my internet. But
I don't either because I'm getting it. I'm getting his responses. So I think the recorder's probably getting it too, but.
I was gonna say I didn't catch hardly any of that last answer.
Okay. All right, guys, what do you propose here? We haven't quite finished this up. Do you want to go with what you've got? Do you want to proffer any more things, Mr. Seward? Or do you want me to, I cannot fit you in the rest of this week. I can find a time for you next week.
Judge, I mean, I think we have quite a bit of time. That Missouri court stayed their proceedings till September 2nd. So they're kind of on hold until we have
Well,
a chance to finish all of this.
That is true, but in the interim, there's nothing going on. But again, if I don't have jurisdiction, then I don't have the ability to really grant anything at this point anyway. And all that's existing is a temporary order, which was discussed, but with the December hearing, but
I mean, Judge, I would still just
no time limit was given. So how about next week? Whatever I can do Monday. If I don't have a jury, I can do Tuesday. I can do Thursday, Monday, Tuesday, or Thursday.
let me look, Your Honor.
Judge, Monday I'm out
Okay.
in court.
Okay.
Tuesday I can do the afternoon.
Okay.
Wednesday's wide open.
Yeah, I don't have as much time Wednesday. It's my duty day and I have first appearances in another court case.
Wednesday I am in a settlement conference.
What'd you say about Thursday? I said Monday, Tuesday, or Thursday.
Thursday I'm in a settlement conference in the morning, and then I have a hearing set from 2:30 to 3. I don't know how much time.
Okay.
I don't have anything on Thursday.
What about Tuesday afternoon? He said he's free Tuesday afternoon.
I have a 2:30 in Newton.
Okay.
Judge, what about moving that plea on Wednesday? It's Joe Favre and Amber's case. I think it's actually Brett's case, if I remember right. You're set by Zoom because he's in custody. I know you have first appearances, but I could see about moving that plea if.
Okay,
Mr.
on
Stewart-
the 23rd, I am out for an appointment at 3:30 or 4. So, and I have first appearances that, lately have been going for an hour and a half.
Right.
So that's 3 o'clock. So that doesn't give any time there. And then in the morning on Wednesday, I have State v. Sweat at 11. And you're saying I have.
That one I was saying, if it was available in the morning for either one of them to potentially move that plea, because he's in custody and he was set last week. They just need to iron out some stuff on the plea.
Okay, is that all I have that you show on the 23rd in the morning?
Yes, yes, that's it.
Okay, so counsel, can you do Wednesday, the 23rd from 9 to noon?
I can do that, Your Honor.
Yes, Your Honor.
Okay, that's when we're gonna finish this up. I am going to keep it by Zoom. Just because I have to do my duty day here. My duty day is here. So what you're gonna have to do is have him come to your office or do some testing to get you know, whenever, I don't know if he's in Madison, different places don't have as high-speed internet as others, and I'm not sure what's going on, but let's make sure that everybody can hear everybody and communicate and see everybody, however you need to arrange that. All right, folks, we're gonna reconvene on Wednesday, the 23rd at 9 a.m. For that entire morning. If there's nothing further today, we're adjourned. I appreciate your patience. Thank you.